Hello all, welcome again for second video lecture on Criminal Procedure Code exam topics. Here I am discussing our FIR, bail, charge, probation and parole, custodial death, grievous hurt causing culpable homicide, and a few shorts like artifice convict, ex post facto law, summary trial, special diary is also called police diary. Coming to FIR, it is dealt under meaning, object, essential conditions of FIR, information in cognizable cases, evidentiary value of FIR, delay in filing FIR, and conclusion. FIR, the meaning, the term first information report, a report has not been defined in the Code of Criminal Procedure. Rather, the term has not been used except in Section 207, which requires the magistrate to furnish to the accused a copy of the first information report recorded under the section 154 class 1 of the code. It may be defined as it is a piece of information given to the police officer. The information must relate to the cognizable offense. It is a piece of information reported first in point of time. The victim of the cognizable offense or someone on his or her behalf gives information and lodges a complaint with the police. This is the information on the basis of which investigation begins. The FIR must be in writing. The objectives of FIR. The main objective of filing FIR is to set the criminal law in motion. It is also to enable the police officer to start the investigation of the crime committed and collect all the possible pieces of evidence as soon as possible. The various objects of recording FIR are to inform the district magistrate and the district superintendent of police who are responsible for the peace and safety of the district or of the offence reported at the police station, to make known to the judiciary and judicial officers before whom the case has to be ultimately tried about the facts and scenario which came out after the immediate occurrence of the crime, to safeguard and protect the accused against subsequent additions or variations. Essential conditions of FIR. In Moni Mohan versus Emperor, it was decided that the essential conditions of FIR are: it must be a piece of information, it must be in writing, if not given in writing, should be reduced into writing by the concerned police officer. The main act or crime should be cognizable in nature, not the ones subsequent to the main act. Procedure for recording FIR. Provisions relating to the procedure for recording information in respect of cognizable section cases under section 154 are: if the information is given orally to an officer in charge of the police station, it has to be reduced in writing by the concerned police officer. It should be then read over to the informant and then signed by him. The information thus received has to be recorded in a book authorized by the state government regarding the same. A copy of the information recorded is to be given to the informant free of cost. If the officer in charge refuses to record the information, the person may send such information, the aggrieved person may send the substance of such information to the superintendent of police, and the superintendent of police, if satisfied about the commission of the cognizable offence, shall either investigate the case himself or direct an investigation officer to be made by the subordinate police officer. Evidentiary value of the FIR. An FIR is not a substance piece of evidence, that is, it cannot be considered as evidence of the facts stated therein. However, FIR may be used in the following purposes. It can be used to corroborate an informant witness under Section 154 of Evidence Act, but it cannot be used to contradict or discredit other witnesses. It can be used to contradict an informant witness under Section 145 of the Evidence Act, and FIR can be used by the defense to impeach the credit of the maker under Section 155(3) of the Evidence Act. A non-confessional FIR given by an accused can be used as an admission against him under Section 21 of the Evidence Act. The FIR can be used as a dying declaration as substantive evidence if it relates to the cause or occasion or circumstances and facts which resulted in the informant's death within the meaning of the Section 32(1) of the Evidence Act. Delay in filing FIR. The object of early filing of FIR to the police as soon as possible in respect of the commission of the offence is to obtain and receive fresh information regarding the circumstances and facts which tend to result in the commission of the offence. Thus, if there is a delay in lodging FIR and the delay is unreasonable and unexplained, it is likely to create scope for suspicion or introduction of a concocted story by the prosecution. It is the duty of the prosecution to explain the delay in lodging FIR. If satisfactorily explained, it does not lose its evidentiary value. In case Raghbir Singh versus State of Haryana, it was held that going to the hospital due to the condition of the victim for saving his life instead of going to the police station first was a reasonable and valid explanation for delay in the filing of FIR. In second case, Harpal Singh versus State of Himachal Pradesh, it was held that delay of 10 days in lodging the first FIR stands reasonably explained when the prosecution stated that as the honor of the family was involved, the members needed time to decide whether the matter should be taken to the court or not. Conclusion. The FIR is the first step of criminal procedure that leads to the trial and punishment of the criminal. It is also the most important supportive evidence on which the entire structure of the prosecution cases is built up. As rightly observed in the case of Mohanlal versus State of Uttar Pradesh, FIR is Bible of the case initiated on the public report. Coming to the next topic, bail. Introduction. The type of bails in India are regular bail, interim bail, anticipatory bail. Types are regular bail, interim bail, anticipatory bail. Conditions governing the bail in a bailable offence. Bailable. What is bailable offence? What is non-bailable offence? Conditions for anticipatory bail and respective case laws and conclusion. Bail. There are many famous personalities who face the FIR against them due to their wrong comments or statement. So, the first work which is done by them to avoid arrest is to apply for bail. The concept of bail is a basic and important part of criminal jurisprudence. Bail is a well recognized principle among the world's whole world's judicial system. The bail is a temporary release from the jail of an accused who has the criminal charged by deposing security to ensure that the person will present in the court whenever the court needs him for further proceedings. All the provisions related to the bail is covered under section 436 to section 439 of the Criminal Procedure Code. What is bail? The bail is the temporary release from the police custody where accused person on bail will be available whenever he needs for the investigation of further proceedings of the court. The Criminal Procedure Code does not define the term bail. However, the term bail indicates that the accused with criminal charges sets free from the jail by submitting a kind of security by the accused. The accused can move the application in the court or police station for bail at the time when the police arrest the person to arrest the or ongoing person in a criminal case. Legal position of bail. The term bail has not been defined under CRPC. Only the term bailable offence and non-bailable offence has been defined under Section 2 Class A of CRPC. The provisions relating to bail and bail bonds are mentioned under Section 436 to 450 of CRPC. Types of bails in India. There are three types of bails in India. A regular bail. When a person commits a cognizable non-bailable offence, the police can take him under custody and after the custody period expires, he must be sent to jail. Section 437 to 439 and 439 of the CRPC gives the accused the right to be released from such custody. So, a regular bail is basically the release of an accused from custody to ensure his presence at the trial. Interim bail. This bail is granted as a temporary means and granted for a short period of time, either during the time of pendency of an application or when the application of an anticipatory or regular bail is pending before the court. Interim bail is always conditional and can be extended, but if it expires before the accused has been granted an anticipatory bail or regular bail, or he fails to pay the amount required for continuing the bail, then he loses his right of freedom and will be taken under custody. Coming to anticipatory bail. Anticipatory bail is self-defining. It is a type of bail which is given to someone who is in anticipation of getting arrested for a non-bailable offense by the police. It is a for a non-bailable offense by the police. It is a very essential bail in recent times because business rivals and other influential people often try to frame their opponents in false cases. This is an advanced bail mentioned under Section 438 of the Act. A person who has been granted an anticipatory bail cannot be arrested by the police. Conditions governing bail in a bailable offence. Section 136 Class 1 of CRPC lay down the conditions under which the bail can be granted for bailable offences committed under the IPC 1862. In this case, the bail can either be granted by the police officer who has made the arrest or by the court before which the person has been produced. Here, the bail will ordinarily be granted against furnishing of security by the arrested person. At the time of granting bail to any person, the bail granting authority must be satisfied that the accused appears to be innocent, that is, he has most probably not committed the offense. That further inquiry for the offence is required to be conducted to find out whether he has committed the crime. The offence is not a major one, that is, it is not an offence punishable with death, life imprisonment, or imprisonment up to 10 years. Types of offences based on bail, bailable offences and non-bailable offences. Bailable offences, according to Section 2A of CRPC, bailable offence means an offence that is classified as bailable in the first schedule of the code or which is classified as bailable under any other law. An accused can claim bail as a matter of right if he is accused of committing a bailable offence. The police officer or any other authority has no right to reject the bail if if the accused is ready to furnish bail. Under Section 436 of CRPC 1973, a person accused of a bailable offence at any time while under arrest without a warrant and at any stage of proceedings has the right to be released on bail. Non-bailable offences. A non-bailable offence is defined as any offence which is not a bailable offence. A person accused of non-bailable offence cannot claim bail as their right. A person accused of non-bailable offences can be granted bail provided the actual accused does not qualify the following conditions. There are reasonable grounds to believe that he has committed an offence punishable with death penalty or life imprisonment, that the accused has committed a cognizable offence and he had been previously convicted of an offence punishable with death, imprisonment for life, or imprisonment of 7 years or more, or if the accused been convicted on two or more instances of a cognizable and non-bailable offence. Important factors to be considered while granting anticipatory bail in India. Based on Section 438 Class 1 of CRPC, the Supreme Court has enumerated a detailed and exhaustive list of considerations while deciding an anticipatory bail. They are as follows. Gravity of crime and role of accused must be understood before the arrest. Previous record of accused, any imprisonment on conviction in respect of non-bailable offence should be checked. Possibility that the applicant will be flee from justice. He will flee from justice or run away from the justice. Chances of repetition of similar or other offences. Intention behind accusation is whether to injure or humiliate the applicant by arresting him or her. Consider the exact role of the accused. Reasonable apprehension of the tampering with evidence, witnesses, and threatening the complainant. Case laws. Re Digendra Sarkar under Section 438 of CRPC, the application for anticipatory bail applied even before the FIR is registered. So, the first FIR cannot be a condition precedent for applying for anticipatory bail. Sushila Agarwal versus State. The Supreme Court held that anticipatory bail should not be for a fixed period, but it is open to the court to limit the tenure of the anticipatory bail if any special condition necessitates the same. Concluding, the bail is an important check and balance to ensure that no innocent person is punished until proven guilty. Grant or refusal of bail depends on factors that are remotely connected with the merit of the case. The recommendations of the Law Commission in its 268th report on bail reforms are important and they should be implemented so that a fair and transparent system of bail evolves in our criminal law system. Coming to charge. The charge under CRPC is defined under Section 2B of the Code of Criminal Procedure inclusively. According to this section, the charge includes any head of the charge when there are more than one heads. The definition is vague. For example, A stole all jewelry in B's house by keeping the housemates at the gunpoint. Here, A has committed house robbery, theft, theft in a dwelling house, illegal possession of weapons, assault, and so on. Therefore, A is charged for all the mentioned offences. Therefore, the term charges in criminal law basically means the allegations or the offences imposed on a person. The main objective of the charge under CRPC is to give basic and exact knowledge to the accused of the offence that he has been charged for it and also give him time to prepare for his defence. The common practice and basic rule are that the charge should be specific and not lengthy. This allows the accused to prepare their defense on the specific charge. Apart from this, it also allows the prosecutor to prepare his case and evidence to start the prosecution. The provisions dealing with charge. The charge is dealt with under Chapter 17 of the CRPC 1973. Section 211 to 214 contents of the charge, 216 to 217 powers of court to alter the charge, 218 says basic rules of charge, 219 to 20 to 21 to 23. These are exceptions considered under charge. Section 224 effects of withdrawal of charges. Section 254, 215 and 464 effects of errors. Form and content of a charge. Section 211 of CRPC constitute essential elements of the contents of the charge. The charge form shall state the offence for which the accused is charged. The charge form shall specify the exact offence name for which the accused is charged. If there is no specific name given under any law for the offence which the accused is charged, then the definition of the offence must be clearly stated in the charged form and informed to the accused the law and provisions of the law to be mentioned in the charge form. The charge shall be written in the language of the court. The accused shall be informed about his previous allegations, which would expose him to the enhanced punishments if found guilty for the offence charged. Case laws. In the case of court in its motion versus Shankaru, the court held that mere mentioning of the section under which the accused is charged without mentioning the substance of the charge amounts to a serious breach of procedure. VC Shukla versus State Justice Desai. In this case, the court held that the purpose of framing the charge is to give notice to the accused of a clear and accurate notice that for what purpose the accused is called upon the meeting during the trial. Tulsiram and others versus State of Uttar Pradesh. The learned judge came to the conclusion that the allegation by the appellants in the case was fully understood by the appellants. It was understood in a way and they never complained at the proper stage that they were confused or shocked by the charge. The sad thing is true here. Therefore, the court refused to accept any complaint related to the error in the determination of the charge. Coming to the topic probation and parole. Introduction. Serving punishment for those who indulge in criminal activities is an important function of the criminal justice system. Imprisonment is the most popular form of punishment and it is said to be both preventive and deterrent. Many scholars are of opinion that a reformative model of punishment is necessary, as our primary aim should be reformation and rehabilitation of criminals. It is necessary that in certain cases offenders must be provided with a chance to redeem themselves. Both parole and probation are recognized as methods of correction and rehabilitation in the Indian criminal justice system. Definition of probation and parole. Probation. The word probation is derived from the Latin word probare, which means to test and to prove. It is an alternative method of correction which is non-custodial. CRPC. In CRPC, the provisions that deal with the probation are Section 360 and Section 361. Section 360, Class 10 explicitly states that the provisions in Section 360 and 361 do not affect the validity of the provisions of the Probation of Offenders Act or Children's Act 1960 or any such law. Coming to parole, the word parole is derived from the French phrase "Je donne ma parole," which means "I give my word," and its dictionary definition is "word of honor." The treatment in the forming of monitoring, direction, and help is ideal for parole. Treatment in the form of monitoring, direction, and help is ideal for parole. In India, the rules regarding parole are provided by the Prisons Act 1894 and Prisoners Act 1900. However, there is no completely uniform law of parole in India, as the state government are free to make their own laws for parole. Differences between probation and parole. Probation refers to the judgment given to the convicts in which the convicts continue out of jail under the direction of the probation officer and follows the direction set forth in the judgment by the court of law. Parole means the former period release of the prisoner on the condition that the prisoner shall be under the control of the respective authority and imprisonment will be continued upon non-adherence of the conditions stated. Probation is approved by the judge as an alternative to the detention. Parole is nothing but an arrangement of the restrictive release from the jail. Pronouncement of the probation of a suspect is given by the court. The parole board gives the pronouncement about the parole of the inmate. The probation is approved to the suspect before imprisonment, that is, despite directly sending the suspect to the prison, they are given an opportunity to rehabilitate themselves through this procedure. Parole is permitted later the wrongdoer has finished a specified period of their judgment term in jail. Probation is granted to those people who have no previous criminal record so far and also for the criminalities that do not involve viciousness. Parole is permitted to those offenders which are previously in prison and also presented to grave offenders who pursue virtuous behavior during the period of their verdict. A person who has approved probation reports to the probation officer, though the default in reporting to the respective authority may lead to the resentencing to the prison for a specific time. The criminal under parole has to report to the parole officer, but in case if the suspect fails in reporting without rational reason, the criminal is sent back to the prison on the grounds of the original judgment. Grounds of probation, section 361. Any person who is not below the age of 21, and is convicted of a crime for which the punishment is either imprisonment of 7 years or fine. Any person below the age of 21 or any woman convicted of an offence that is not punishable with a life imprisonment or death penalty and the offender has not been convicted in the past. Above persons appear before the court may release the offender on the promise of good behavior and good conduct on entering into a bond with or without sureties to serve the sentence if called by the court during the fixed period. As per sections 363, the offender can be released if the offender has not been convicted in the past. As per 363, the offender can be released if the offender has not been convicted in the past and the offender for which he is convicted is theft in the building, or dishonest misappropriation, or any offense under IPC that is punishable with imprisonment of not more than 2 years or with a fine only. Grounds of parole and refusal of parole. Some of the grounds on which parole is permitted are grave sickness of a close family member, death of a family member, the accident of a family member, the marriage of a family member, delivery of a child by the prisoner's wife, serious damage to the life or property of a family member due to natural calamity. The following are the types of offenders who are refused from parole: who are not citizens of India, convicted of crimes that pose a threat to national security, convicted for crimes against the state, violation of disciplinary rules in prison. Case laws, probation. In the case of Ahmad versus State of Rajasthan, the court stated that this provision cannot apply to a person who has used explosives to incite communal tension. In case of Full Singh versus State of Haryana, the court stated that the probation on the ground of good conduct cannot be granted to someone in his 20s who has committed a heinous offense like rape. Parole. In case of Election Commission of India versus Mukhtar Ansari, the Honorable Delhi High Court declared that custody parole cannot be used as a substitute for bail and cannot be extended for long periods of time or for a daily visits. Inder Singh versus the State Delhi Administration, the Supreme Court stressed the importance of allowing parole to be used liberally, especially in the event of grave offences. Coming to the next topic, custodial deaths. Custodial death is the occasion of the demise of a person who has been confined by the police or being inducted or being under trial. They can be arranged into three general classes: death in police care, death in legal guardianship, and death in the authority of safeguard or paramilitary powers. The police organization is constantly scrutinized for custodial deaths, torment, and the utilization of unlawful methods during the interrogation. Illegal arrest and detention. The powers given to the police administration for the purpose of dealing with the crimes in the society are many times used by them to implicate innocent and poor people in false and fabricated cases under local and special laws such as the Excise Act, Arms Act, Gambling Act, Suppression of Immoral Traffic Act, Motor Vehicle Act, etc. If an It is an accepted fact that such arrests mostly lead to immense physical and mental torture on the person arrested, due to which he or she ultimately commits suicide in the prison and dies because of the torture. The National Police Commission in 1981 admitted that around 60% of the total arrests made by the police are unnecessary and unjustified. What causes custodial violence? It is primarily very essential to study the reasons behind the problem of custodial violence. Work pressure. Insurgent groups, which are nowadays cause chaos and massacre in many areas, consist of well-trained criminals who are highly motivated to their cause and do not reveal any information quickly. In such situation, the mental pressure becomes a reason for adopting brutality as a means to retrieve information from the criminals. To show results. Once a case is recorded in the police diary, its status has to be filed in the court. To show better results, they sometimes resort to illegal arrest, unlawful confinement, or detention of people and prove case against them. This has a dual effect on the legal system. The wrong person is detained and hence his liberties are violated. The real statistics about crimes are prevented from being come out. Reformation. Sometimes the police have to resort to the tactics of violence to prevent the criminal from committing the crime again. They believe that showing the worst consequences of the act will create fear in the mind of the culprit and thus prevents the possibility of committing it again. Punitive violence. Usually, an officer who is morally affected by witnessing the crime wants to punish the culprit. Although they do it for the betterment of the society, they have to face the accusations of illegal detention and torture and have to prove it in their favor. The landmark judgments are Nilapati Behra versus State of Orissa. The facts are the mother of the deceased complained that her son died in the custody of Odisha police after being beaten up and claimed compensation for violation of her son's fundamental right under Article 21 of the Constitution. It was held that the court held the state as responsible for violation of fundamental rights and ordered the criminal proceedings against the responsible police officers. More importantly, it ordered that compensation of rupees 1.5 lakh to be paid to the family of the deceased because before this case there was no structured formulation to grant compensation on cases of custodial death. Joginder Kumar was the state of UP. The apex court ordered that no arrest can be made on mere allegation or suspicion. It issued several directives on the modalities to be followed at the time of arrest. The arrested person would have the right that any of his friends or relatives be informed about his arrest and location of detention. The police would inform him about this right and make a suitable entry in the diary of the particulars of the person who has been informed of the arrest. The magistrate before whom the arrested person would be brought would also ensure that these directives have been adhered to by the police. Coming to next topic, grievous hurt causing culpable homicide. What here we should know about hurt, grievous hurt, culpable homicide, and culpable homicide amounting to murder, and difference of culpable homicide and murder. Hurt may be described as a bodily pain that is resulting from real contact with the frame by an aggravated assault. There is no radical difference between assault and harm. Section 399, 319 of the IPC 1860 defines hurt as whoever reasons bodily pain, disorder, or disease to any man or woman is said to have caused harm. Coming to grievous hurt, the draftsman of IPC found it tough to draw a line among those physical hurts which can be severe and people who are moderate. However, they special certain types of hurt as grievous hurt. The following kinds of hurt only termed as grievous: emasculation, permanent injury to eyesight or either of the eye, permanent deafness, or injury to either of the ear or eye. Privation of any member of the joint, that is loss of limb, impairing the limb, permanent disfigurement of a head or face, fracture or dislocation of bone or tooth, any hurt which risks the life or which causes a victim to be during the time of 20 days in severe bodily pain or unable to follow his ordinary pursuits. Coming to culpable homicide, Section 299 of the IPC reads as follows: whoever causes death by doing an act with the intention of causing death or with the intention of causing such bodily injury as is likely to cause death or with the knowledge that he is likely by such act to cause death commits the offense of culpable homicide. Culpable homicide is punishable by law and is further divided into two categories: culpable homicide amounting to murder, culpable homicide not amounting to murder. Section 300 of the IPC says culpable homicide is considered as murder if the act is committed with the intention of to cause death and the act is done with the intention of causing such bodily injury for which the offender has knowledge that it would result in death and the person has the knowledge that his act is dangerous and would cause death or bodily injury but still commits the act. His This would amount to murder. Exception to 300, Section 300 of the IPC. Exception to Section 300 of IPC, where culpable homicide is not considered as murder. They are grave and sudden provocation, private defense, exercise of legal power, without premeditation or in sudden fight, consent in case of passive euthanasia. Reg versus Govinda. The accused had knocked down his wife, kept a knee on her chest, and gave 2 to 3 violent blows with the closed fist on her face. This act produced extraversion of blood on her brain, and afterwards the wife died due to this. The act was not committed with the intention of causing death, and the bodily injury was not sufficient to cause death in the ordinary cause of the nature. The accused was liable to culpable homicide not amounting to murder. Dakhi Singh versus State. In this case, the appellant was the constable of railway protection force. While he was on duty, he killed a fireman unintentionally while he was firing bullet shots to catch the thief. The constable was entitled to benefit under this section. Radhesham and others versus State of Uttar Pradesh. In this case, the appellant was extremely angry when he got to know that his cop had come to the deceased place. The appellant started abusing the deceased. When the latter tried to stop him, the appellant fired at the deceased. The deceased was unarmed at this time, thus, the appellant had an intention to kill the deceased. Hence, he was held liable to murder. Ex posto facto la. This is a short notes. Ex posto facto la is a Latin word which means after the fact or out of the aftermath and is also known as retroactive laws. Ex posto facto laws are those laws which are enacted after an action is committed, making such an act illegal, although it was legal when committed. In the literal sense, it's a law which criminalizes such conduct which was once legal. Countries like England don't prohibit this law, whereas USA and India, etc., prohibit this law. Summary trial. The word trial has not been defined in the CRPC. A trial is a procedure where the court adjudicates after hearing the case from both sides. It gives a fair opportunity to examine, re-examine, and cross-examine the witness produced in the court. Summary trials are mentioned in the chapter 21 of the Code of Criminal Procedure 1973. In this trial, the cases are disposed of speedily as the procedure is simplified and the recording of such cases are done summarily. In this type of trial, only the offences which fall into the small or petty categories are tried. The objective of summary trials is the expeditious disposal of cases to lessen the burden of the judiciary. The trial gives a fair opportunity to the people for procuring justice in less time. Doctrine of atrius conflict, atrifois convict and atrifois acquit. The principle atrifois convict means formerly convicted and the principle atrifois acquit is formerly acquitted. The same principle is also accepted by the various Australian courts by the name issue estoppel. Atrifois convict is a defense plea that is followed and accepted by the common law countries. This plea ensures that no person is convicted twice for the same defense. This plea will stop the entire proceeding. The concept of double jeopardy is also prevented by our Indian Constitution. Section 300 of the CPC provides that a person once convicted or acquitted not to be tried for the same offense. Special diary or police diary. Section 172 of the Code of Criminal Procedure 1973 deals with the case diaries. This case diary is also called special diary or police diary. A case diary is a diary mentioned by the police officers while investigating a case which contains details of how the inquiry was carried out and the other particulars such as the date on which the investigation began, places visited as a part of the investigation, etc. They are inadmissible as evidence, however, they can be used to aid the court while the investigation or trial. Case diaries should only mention relevant and actual steps taken towards proceeding with the investigation. Details about witnesses should be invariably recorded too. All the best for your exam. Thank you. Please like, comment, share, and subscribe.